on Earth, it's captured in our atmosphere, so it doesn't really make it to the ground. But on the moon, there's no atmosphere. So helium-3 has been baked into the ground called the regolith for billions of years. The difficult part is the extraction part, which we will bring up in other of our live series because the concentration of helium-3 is about 1 to 15 parts per billion. The good news is there's an estimated 1 million tons of helium-3 on the moon. That's a wild guess, but it's probably within a couple 100,000 tons of helium-3 on the surface of the moon. Well, who cares if it's on the moon? We should care because there's use cases of helium-3. Presently, right now, we use helium-3 for many things, but since our supply is dwindling, these uses are going away. The most important one is to attack bombs, nuclear bombs at borders. In the future, if nuclear fusion, which is up and coming, is powered by helium-3, it will be the only scalable green energy across the globe, the only scalable green energy. Nuclear fusion coming online now without helium-3 is not green, and that'll be a discussion for another one of our series. It's also used for quantum computing. Quantum computing is wickedly fast, and ironically, you need helium-3 to cool the computers down to nearly absolute zero, to 0.01 Kelvin, for a quantum computer to operate successfully. So there's a lot of it on the moon. We have use cases, but it would never make sense unless the revenue to go get helium-3 overcomes the dramatic cost to go into the moon. So the current price of helium-3 is roughly $30,000 a gram or $30 billion per ton. And for nuclear fusion, if nuclear fusion spread across the globe in the future, and all it used was helium-3, you need about 570 metric tons from the moon per year, which is about $17 trillion worth of revenue, which will overcome the expense of going there to get it and return it. Quantum computers still needs a fair amount at about 4 metric tons, we believe. So for more than 60 years, the moon's been a cost center. Apollo, 7 or 8 countries have gone to the moon, we've flown around the moon, they've put landers on the moon, they crashed into the moon. All these events up until this point have been government cost centers, even including the Artemis mission coming out. These are not revenue generators. They serve a purpose such as research or preparing to go to Mars. We believe that helium-3 is the only resource on the moon tied to large-scale demand on Earth. In other words, we know there's titanium and gold and other resources on the moon, but the cost of extracting them is too great just to go there for those resources. We are hosting these conversations because we want to discuss this across the globe. Our series solely focuses on helium-3. Our questions span space, energy, and economics. And our series, again, exists to explore these questions about helium-3 publicly. So again, the series title is From the Moon to Earth, the Trillion-Dollar Helium-3 Frontier. Today's topic is who owns the moon. The assumptions for discussion are that helium-3 can be technically mined on the surface of the moon. And again, we'll go through that in future series. And the focus today will be on legal topics directly related to mining helium-3 from the surface of the moon for Earth uses. And with that, I'm going to stop sharing my screen. And we're going to invite our panelist and our moderator to come on board. So Ken, I'm turning it over to you. And
sounds great. All right. Well, good morning, everyone. For most of human history, when valuable resources were discovered, the next questions were fairly predictable. Who owns it? Who controls it? And what happens when others want it too? On the moon, we're about to face those same questions, but without the legal infrastructure we typically rely on here on Earth. So before we get into treaties and policy proposals, I want to start with the foundation. Why is mining on the moon such a legally complex problem to begin with? This isn't a hypothetical. It's a near-term governance problem. With that opening, let me start with questions to the panel. So, at a high level, why is mining on the moon legally complicated in the first place?
All right, so I can kick us off, Ken. The easiest way to lead into this would be to understand that we're coming from a prohibitory premise. So those who are not familiar, the Outer Space Treaty basically says that you cannot have national appropriation of moon and outer space, right? So we are not operating from a permissive regime to begin with. The answer, if you look at the Outer Space Treaty, says no, you cannot have national appropriation. Then we have to get deeper into it and look at whether extraction of resources, to put it quite simply, constitutes national appropriation. And that's where I think the crux of the debate begins. And that's why it's so complicated, because we have a treaty that was created in the 60s for government actors, right, to prevent them from planting flags on the moon. And we're now applying those principles to technology that is moving at a much faster pace than frameworks, regulations, and laws. And I'll put it to my other panelists to chime in.
Yes. Hi. So basically, I mean, from my point of view, I mean, the basic difficulty is that we are going to do space resource utilization in an environment, space, which is not subject, is not the territory of anybody. So this is new. I mean, of course, Article 2, as Neha said, provides that you cannot have national appropriation. And here we don't even want to discuss what national appropriation means, because there's some opinion, according to some, maybe private parties are not under the umbrella of this general ban. So for the sake of the argument, let's assume that actually the ban on national appropriation applies to everybody. So now we are trying to determine whether you can mine even if you don't own, is not owned by any state. And this is difficult.
Yes, and just my 2 cents. Good morning, everyone. I very much agree with Nea and also Francesca. I think that the difficulty that we have here is that the moon, as outer space in general, is an area that everyone is entitled to use, but actually, no, it doesn't belong to anyone. So you can use it, but you don't own it. So in other words, it is a shared area. And where do we draw the line between rights and duties of individual states and actors? That is the difficulty that we have, because from the treaties, we don't get a neat and clean answer to this question.
Right, and I think Nia made a point. I just wanted to clarify, maybe you could elaborate just a little bit. You're talking about the 1967 Outer Space Treaty. Can you tell us a little about it for the audience so that they can understand where you were coming from?
Yep. So Rosanna, do you want to take that one?
Yes, absolutely. So in terms of international treaties that regulate outer space, we have 5 of them. And the Outer Space Treaty is the first one that was adopted, the most ratified today. And it really establishes very basic principles, not specific rules, principles on what we can do in outer space, the type of activities, peaceful activities that we consider to be useful. So what type of principles it contains? The non-appropriation, which has already been mentioned, meaning that no state can claim sovereign rights on the moon or outer space and so on and so forth. The principle of the peaceful, obviously, uses of outer space, the idea of due regard, having considerations for the activities of others as well when you are doing stuff in outer space, and so on and so forth. These are really high-level principles, but so high that other treaties were required to clarify some of those provisions. That's why we have, for example, the Rescue Agreement of 1968, the Liability Convention of 1972, the Registration Convention of 1975, And then we have the more controversial Moon Agreement of 1979, which is not very successful. After that, and up until today, the way international space law has evolved is through declarations of principles more than anything else. But they are not, strictly speaking, legally binding. So today we are in this situation, as Nea was saying, where we have very old treaties from a temporal perspective, which contain broad principles. And principles can be interpreted in different ways by different actors, being implemented also in different ways. And that is where the game or the policy elements kicks in.
And I'll just add that, we have, I think, around 115 or 116 parties to the Outer Space Treaty. It includes all of the major spacefaring nations. Now, do they all agree on how these principles are interpreted? No, absolutely not. And, I suppose we're going to dive into that in some of your other questions, Ken.
Yeah.
Okay.
If I can add the point of the Outer Space Treaty in Article 2, I mean, Rosanna mentioned the other treaties, and the other treaties, they spell out some specific provisions of the Outer Space Treaty. So, for example, you have the Registration Convention that spelled out the Article 8. And then you have the Liability Convention that spelled out Article 7. Now, we don't have a specific treaty on Article 2. We don't have a specific treaty on Article 9. And when you don't have there's a detailed treaty on, you only are left with a general provision. That is why so much has been written about Article 2, Article 9. Not, we haven't written about the other articles, but they're really more obscure because there was no specification.
Thank you.
Okay. Here's one for you. I like this one. What makes the moon different from other sort of regulated domains like our Earth-based space, the airspace that we operate planes in, water that we operate transportation on our oceans, or even Antarctica? How is the moon different from Earth-based sort of domains?
So the easy one is airspace, right? What we were just talking about in Article 2 of the Outer Space Treaty, where there's no national appropriation, and you can't, claim sovereign rights over the moon. You have a treaty called the Chicago Convention that essentially says that a state has sovereignty over its airspace, the airspace above its territory, right? So you are coming from two different angles here, where we have the most foundational principles on, when we're talking about airspace, for example, whose territory is it? Whose jurisdiction is it? Who has rights over it? Who's the sovereign state that governs it? Those foundational principles have been determined over time, right? Whether it has been through war, through conflict, through court cases, but we have those principles in place, which we do not have in place for the moon, and we're starting from a reverse position of like nobody can claim the moon, right? There are certain things you can do there, but nobody can claim the moon.
Is maritime law like the precursor for all of this?
I can take this. I mean, I believe that the high seas are really one of the best analogies that you can think of. First of all, I mean, we have to distinguish the situation of the oceans from the situation of space, because talking about the oceans, you have a layered jurisdictional system. So it is divided into territorial sea, which is up to 12 nautical miles. Then you have the exclusive economic zones. Then you have the continental shelf. And then you have the high seas and the deep sea bed. Now, sometimes I hear the analogy with a deep sea bed, but space is different because in the deep sea bed, you have International Seabed Authority. And by the way, it has been very controversial. I mean, they have to amend the UNCLOS to make it palatable for many states. But anyway, you have it. In space, you don't. In my opinion, I mean, a very good analogy instead is high seas, because it's a place in which you have the freedom of navigation and also of use by all states. So you can fish, but you cannot say, this is my portion of the high seas and nobody else can fish here. You cannot do that. I think if you want to think of an analogy for the moon, I think this is a good one.
Rosanna, do you have any thoughts about that too, or any other twist?
Yes, I'm a little bit more skeptical about analogies. I don't think they work very well with outer space because of the premise that we have just discussed. No sovereign rights are admissible. When it comes to the law of the sea, the UN clause, the UN Convention on the Law of the Sea, and so on and so forth, yes, there is probably a parallel up to an extent that we can draw between outer space and especially the high seas and the deep seabed. But actually, the way they are regulated, the deep seabed and also the high seas, is that the area as such is described as the common heritage of mankind. And so there are some duties attached to it, including benefit sharing, using in a certain way, and so on and so forth. And that's why we have the International Seabed Authority. There is nothing like that in outer space. So the pure analogy is difficult to frame and to justify. Probably the Antarctic Treaty is useful in other ways. It has actually influenced some of the provisions of the Outer Space Treaty, like the right to visit installations and so on and so forth. They were really borrowed from the Antarctic Treaty system. But that is where it ends, because the Antarctic Treaty freezes sovereign rights in that area. And that is a situation that we are excluding from the beginning from outer space. So I do believe that we need, a fresh start when it comes to regulating outer space without relying too much on our terrestrial analogies.
Yeah, I mean,
Sorry.
sorry, no, just a point. I mean, I agree with Rosanna that we need a new framework because, for example, you have Article 7 in the Antarctica Treaty that prohibits basically the use of mineral resources other than scientific research. So this obviously doesn't apply to our space. So also the analogy of Antarctica has to be taken with a grain of salt.
Super. Well,
I'll add,
go ahead.
I just want to quickly add, to sort of echo what Rosanna and Francesca have said. This is, operationally and logistically different, right? The sheer distance between Earth and the moon alone makes it it has to be a different framework. We cannot, we can create analogies, we can, we can have theories and we can write papers and publications on it. But for practical purposes, it has to be a different framework. And it is moving forward as a different framework, right?
I like that. That beautifully moves into, let's anchor that in the legal reality we actually have today. We've framed why this is complicated. Now I want to turn to what the law currently says, because in many ways, the tension here comes not from the conflict between the laws, but from the gaps between them. So I think Chris has another question.
Well, I want to do a tiny tangent because sometimes panels allow you to do that. I want to go back to Antarctica because I think it's an interesting, if you put it in perspective from my history, if I remember correctly, it probably goes back to the 50s, 1950 arena. Sometime back when the political landscape across the globe was very, very different. And people talk about the Antarctica Accords and treaties that it's ironclad. But what would happen with our political environment now if anybody, United States, Russia, China, went there and started to mine? We've talked about it like it's ironclad, and it was a couple decades ago, but I wonder if that would be broken by anybody due to money or resource utilization. Any thoughts about that? Is it still as solid as it was in the 70s, 80s, and 90s?
I think that things are evolving, and actually this very topic in many respects is being discussed right now at the UN Committee on the Peaceful Uses of Outer Space, which is, so to speak, the global governance hub for outer space. So the discussions right now are centering around the legality of the use of the resources of outer space, could be helium-3 from the moon, and other resources, especially the mineral ones from other celestial bodies as well. Now, there is one bit of the story which is largely accepted. So you can go and mine resources if you're going to use them in support of scientific missions, like the Artemis missions, probably the equivalent in the International Lunar Research Station program by China and Russia, and so on and so forth. So you can go and use resources if you are supporting research. Now, what is the problem? The problem is that we are not entirely sure from an international law perspective is whether you would need an ad hoc, so a specific framework or certain additions if you want to use those resources, mine, for example, those resources for commercial purposes. So for the purposes of generating revenues for yourself, what would be the benefit for the international society to have those activities in place, and so on and so forth? So there is no moratorium, no prohibition as such. It's more about how you're going to do that. Environmental consideration, distributive considerations, and so on and so forth. Next year, so 2027, there should be a new declaration of principles issued by the United Nations Scopus. Hopefully it will provide some more guidance. It's not legally binding, but it will basically take into account the state of not only the treaties, but also the state practice that is going to happen on the moon initially, but also in other celestial bodies as well. So everything is evolving right now.
If I can interject here, I mean, I have a kind of more definite answer about that. In my opinion, you can commercially use the resources of the moon. And I have analyzed in a paper the national laws that has been issued. In my opinion, the national laws, and there are 4 plus another couple inserted inside the general space activities law, they function as state practice. And of course, there are also consideration about the Outer Space Treaty, which is expressed in very general term. I mean, when we are talking about the ban on national appropriation, if we apply that by itself and we say, well, maybe you cannot use resources commercially, then you have Article 1, which is freedom of exploration and use. Now, if you say that I cannot use, so this becomes an indeedis. I mean, it's exploration and exploration. So instead, the treaty says in Article 1, freedom of exploration and use. And I think mining is included in the freedom of use. In addition, the 4 laws that has been issued, the United States law 2015, Luxembourg 2017, the UAE 2019, and spelled out again in 2023, and Japan, of course. Well, these laws made clear that you can mine the moon, you can mine space in general, also the asteroids, for example, and you can appropriate, you have property rights on those resources. I think this kind of activities by states include, and in addition, the Artemis, of course, and the parallel Chinese and Russia initiatives, they have to actually, not without mind, they have to count as state practice interpreting the Outer Space Treaty. So how can something be questionable, I mean, legally questionable, if you have countries that are passing laws that allow you to do that very activity?
Well, so a couple of questions to that, and that there are major players, and so one question is, what are the major players? And then you talk about, laws passed. Is there kind of an agreement with these different players, or is there like fragmentation in what different countries' understandings are?
Yeah, so there's definitely fragmentation. And before I get into that, I want to touch upon something important that Francesca said. And I think it's very important for this audience to know from a US perspective, right? She mentioned the Commercial Space Act. And I don't know how many in the audience have actually gone and read the space resource provisions of the act. But it basically says that a US citizen, which is defined, by the way, and there's an interesting definition to that, shall be entitled to space resources obtained, including to possess, own, transport, use, and sell. That is a very broad entitlement that is in our federal statutes, right? But then it goes on to qualify it, right? And it says it has to be in accordance with applicable law. Now, anyone who's an attorney will see that as a very loaded sort of qualification, right? To something that's a very broad right? With applicable law, including the international obligations of the United States. So you read like these one or two sentences, right? These are loaded provisions, but they are on the books, they're in our federal statute, and US citizen has a very interesting definition as well. It includes a foreign entity that has a controlling interest from like a United States natural citizen or a United States entity. So I just wanted to put that out there. And of course, the US has always taken the position that it does not view space as a global commons. So that again becomes a very big point of contention on the international stage, because not everybody sees things that way, and the US has been criticized for its Space Resource Act.
Yeah, but in the meantime, you have had other countries passing that. So, for example, Luxembourg goes as far as to say that the space resources are susceptible, amenable, depending on how you want to translate French, as amenable to appropriation. So to me, it's really a reference to Article 2. So it's a parallel, exactly as Article 2 makes reference to ban on appropriation. Luxembourg is telling us that the resources are instead amenable of appropriation. And the United Arab Emirates law also defines not the 2019, but the following cabinet resolution defines space resource activities to include owning, purchasing, selling, trading, transporting, and storing. And Japan does the same. And by the way, Japan has issued a license for mining to a mining company. And two recent general space activities laws, Brazil 2021 and Italy 2023, expressly mention the exploration of the use of space resource and among the activities that are allowed. So all of that must mean state practice. Maybe it's not like going there and actually mining them, but it matters, in my opinion.
And probably Rosanna can comment on the Artemis Accords, right? I just want to put in a short note that the United States has done something very smart, right? In addition to having its Space Resources Act, it's getting buy-in from countries around the world through the Artemis Accords. And I know Rosanna is sort of the expert here on that, and I'll let her chime in.
Thank you. Thank you very much for the invitation to say a few words on the Artemis Accords. First, what are the Artemis Accords? They are just a set of guidelines, so to speak, that accompany the Artemis missions. Why? Because the Artemis missions, as opposed to the Apollo missions, which were by one country doing stuff on the moon, are going to be collaborative missions. So there will be a group of states working together. And in order to ensure that everyone, for example, sticks to the same standards of behavior on a technological front as well, and so on and so forth, they have put together this set of guidelines. Very short, just 10 principles, no more than that. What they want to do at the same time is to, they say, operationalize the Outer Space Treaty, which means making a little bit more concrete, otherwise those broad principles about non-appropriation, potentially also including the use of space resources, due regard, and so on and so forth. So actors, private or public, it doesn't matter, but the actors on the ground or off the ground in this case can actually act in the same way, sticking to the same standards. Obviously, the Artemis Accords embed also the interpretation that the United States is imparting to key provisions of the Outer Space Treaty in particular, starting from Article 2. So they say Artemis missions, by the way, are scientific missions. So all these and also the reference to the use of space resources is in support of scientific research. So the US very, very cleverly, in my view, stated clearly that using resources of the moon, of Mars, other celestial bodies in the solar system in support of scientific research does not amount to a violation of the principle of non-appropriation. And in doing that, they are clarifying how you are supposed to mine those resources by setting a safety zone and so on and so forth. So what they are doing, they are moving forward our thinking on the standard setting for lawful mining of resources, which probably, as more states endorse the Artemis Accords in the abstract, but also start doing stuff on the moon, implementing the Artemis Accords, will probably turn them into a sort of blueprint for commercial space mining properly. So that is my 2 cents on the relevance of the Artemis Accords and also the link, especially with the Outer Space Treaty.
It sounds like the Artemis Accord, from where you're coming from, is maybe a leading coalition or potential coalition with states. What are some of the other institutions and coalitions trying to fill in that void?
Yes, I mean, if we look at what is happening right now from a more geopolitical perspective, there is the Artemis bloc of states. They have already collected 61 states endorsing that way of using outer space, including the resources. And then there is the other parallel program, which is more a work in progress, so to speak, the International Lunar Research Station by China and the Russian Federation. They have announced back in 2021 that they will release a sort of equivalent of the Artemis Accords document, sort of legal guidance on how to do the same activities, so using resources in support of scientific research, but within their own framework. We're still waiting for them to disclose what will be the legal signposts that they have identified to mine lawfully. But the thing is that there is very little scope for maneuver here. Either you basically go down the line of the Artemis Accord and say there is no problem whatsoever using the resources of the moon, Mars, or other celestial bodies in support of scientific research, setting somehow the standard also for commercial space mining, or you will have to go back to the creation of a system pretty much like the one we have for the law of the sea, with an international institution authorizing you to do stuff and probably also imposing conditions like benefit sharing and so on and so forth, because the bottom line would be that you do not allow states to claim sovereign rights whatsoever on outer space, obviously, but also on the resources extracted.
Yeah, and here, if I can say, I mean, if that's the opinion that will come to be majoritarian, we would have a problem because we haven't been able to pass a space treaty since 1979. And also the one that we passed in 1979, the Moon Agreement, was not very successful. So I mean, international treaty would be, of course, a good thing, but I think it's unrealistic to think that we can, in the current geopolitical situation, get to the point in which we will sign actually a treaty. So, in my opinion, and that is a paper that I'm writing just right now, it's we should interpret, we have the instruments of interpreting the Outer Space Treaty in order to be commercially friendly. And we have to do it if we want to, for the Outer Space Treaty to continue to be relevant. Otherwise, we would take this beautiful treaty, which is really the constitutional space, And we won't have another, in my opinion, for a long, long time if geopolitics remains what it is. And basically, it risks to become irrelevant. People will just formally say that they respect it, but then they will just continue to do their activity, which is, if I can say, a little bit is the position of China. China is very, very, what can I say, on paper, they are very internationally friendly, but then they do their own activity, like the International Lunar Research Station is just one of those. I mean, space resource utilization is central to that project. So, of course, they can say we have to discuss about that, we have to find an agreement, but then they envision that for sure.
And I'd say that a third, sort of not necessarily a framework or an institution, but a very visible driver is the commercial space industry, right? That's not a player that was in the mix in the 60s or 70s, but very much a driving force here. And I sometimes think that when, business folks get into the room with politicians, they can drive things faster. Maybe they can drive things to more of a collaboration. We've seen this as a very sort of small example, right? What we've done with the private missions to the International Space Station through Axiom Space. That is something that probably wouldn't have been contemplated in the 60s or 70s, but it has taken place now. So I would put a lot of weight on the commercial actors, and I have a lot of hope that they can drive agreements that perhaps governments have not been able to drive in the past. And it doesn't necessarily have to be a treaty, as my fellow panelists have said. Soft law can be just as effective because there's a consensus that goes behind it, as like a treaty would be.
By the way, we have a little bit of a hum going on in the background, so I'm not sure if it went away. So I just wanted to point that out. I think it's gone now.
Sorry. Yeah, I heard that. Well, so that's interesting. Once real economic stakes are introduced, and I kind of want to get into conflicts. Conflict is no longer a hypothetical, it's an inevitable. I think we all see like, oh my God, where's this going? The focus then shifts to identifying mechanisms, if any, exist to manage or resolve those disputes when they arise. So another question for you guys is, do current frameworks effectively allow de facto property rights, even if not formally recognized, as you said, is being driven by, business entities as opposed to governmental policies?
Well,
I've stumped everyone.
the short answer I would say is no, right? There's no, because a lot of this hasn't been tested, and we have to sort of keep that in mind, right? It has not been tested. We don't know how things will fall, where they will fall. We can take Artemis Accords for an example. What Rosanna mentioned about safety zones, right? There's some very detailed provisions in the Artemis Accords about notification, setting up of safety zones. And these zones have to be sort of commensurate with, the operation itself. But what happens when a mining operation takes years, right? And you set up on the moon and you do it according to the Artemis Accords, which again is fragmented, right? You don't have buy-in from all countries. And somebody else who is not part of the Artemis Accords, right? Let's say it's Russia or China, comes in and wants to set up in the same spot or right next to you something that infringes upon your zone. Do you have a first mover leverage? Do you have a first mover right? I'm sure you can start creating those, right? You can start creating those by being there first. You definitely have an advantage, right? There's an old saying that like possession is 9/10 of the law. Not sure if it's going to apply on the moon, but by being a first mover, you have rights, but that's not without risk, right? There's not without risk. I know in the past we've had some discussions about how do you secure your mining operations. So when you start putting all these pieces together, right? You have an operation, you have a safety zone, you're there for many years, you're now securing your operation with maybe security personnel or military personnel. Does that become a property right, in essence, but without calling it appropriation? The question
Yeah.
to your question.
Yeah, if I can interject here, I mean, yes, I mean, you will have a situation of de facto control. So I cannot qualify that as appropriation because, of course, it's prohibited by the treaty. But you have instruments. You have like due regard, for example. It's very vague. As I said before, there have been some provisions of the Outer Space Treaty that have been spelled out. Article 9, due regard, has not been one of those, unfortunately. So I recently wrote a paper about non-harmful contamination, for example, which is very much connected to the environmental issues that somebody mentioned before. I'm not so sure. I believe it was Neha, maybe. So unfortunately, we don't know exactly what it means. I would like to point out that due regard is not unilateral, is bilateral, actually. So exactly as the first mover has a right to be undisturbed in his activities, actually also the second mover has the same right. I've written a paper about that, and the title was just Does Due Regard Confer a First Mover Advantage? And I don't think it does, actually. So you will have conflicts, you will have interferences. It is not only a question of having an interest on the same spot. It is also conducting activities that are incompatible. So you have mining activities and you have radio astronomy. Just even far, but you need a lot of space for radio astronomy. So you have this type of situation. You will have interferences, and the possibility of conflicts on the moon is very real.
So, how do I say this? Doctrines of ambiguity. So do you mean that like non-appropriation means you can't own resources, or just that you can't claim territory, or, you know?
That's a very good and difficult question, the $1 million question for a space lawyer. For sure, you cannot claim sovereign rights on the celestial body. For example, if you are mining on the moon, you cannot say the moon is mine, and therefore you proceed with your mining. The question which remains open, and here is the source of the protracted debates from the Outer Space Treaty through the Moon Agreements, through the declaration which is coming through hopefully next year, COPUOS and the General Assembly, is whether you can admit, okay, I don't own outer space, any celestial body, and so on and so forth, but I can own the little rock that I can extract, okay, or mine from the body. Now, for sure, Outer Space Treaty, Article 2, in my view, do not impose any moratorium. So for me, you could even go as far as to say this is mine, so claim property rights on the resources that you are extracting. The problem is how you are going to mine those resources. And here is where also Francesca was saying, all those principles of the Outer Space Treaty come in. Due regard, what is the meaning, for example, of setting a safety zone? How do we ensure that you are respectful in extracting those resources, and so you are not using too much compared to what others also may need, and so on and so forth, in context of a scientific mission? And probably same type of question arises for commercial space mining. Can you just mine for the sake of mining, or do you mine because you are able to resell? So you mine only the amount that you need in order to have your business running, and so on and so forth. So you are respectful of the needs of the other potential states and users of the same celestial body. For me, what is happening is that it's only through state practice, so people and states doing stuff on the moon, that we will disclose once and for all what are the acceptable standards on how you mine the moon, Mars, asteroid, any other celestial body. Once they are approved by the international community, then the line between mining for scientific research and mining for commercial purposes properly will almost entirely disappear. But because the treaties precede state practice, we are still reasoning in the abstract. Is this feasible, not feasible? It's all about start doing stuff and then understanding what is acceptable for states as a whole that will disclose what is the correct today interpretation of the Outer Space Treaty. My 2 cents, but the Artemis missions, the International Lunar Research Station, and also the discussions going on right now at COPUOS kind of go down the same line, to be honest. It's state practice that will make the difference at the end of the day.
Here's a time check. We have about 6 or 7 minutes before we take. There's a number of questions from the audience, so we'll reserve some time. I'd like to interject a little bit of pessimism. If you look at satellites around the globe, it was one thing in the 50s and 60s. There were one-off items, sort of like going to the moon to extract helium-3, sort of one-off items here and there. No one paid much attention, but look what's happening now. We have the US with multiple large constellations. SpaceX wants to put up 1 million satellites. They've announced it to the FCC. China has their own very large constellation. Something bad's going to happen because there's something called the Kepler effect. If one satellite hits another one and breaks up into a million little pieces, that's going to cause a domino effect and can take out all the satellites around the globe, including global positioning and communications. So I don't see a lot of cooperation taking place between China and the United States as the main actors putting up these satellites. That's 70 years of history. Maybe that same thing might happen on the moon, but it should be interesting to look at what is happening with what was a public thing, rare satellites, to now what's commercially being driven by businesses and a potential catastrophic event taking place around the globe. Anybody have any thoughts about how that might be a precursor for the moon?
So, Chris, I'm a little bit more optimistic, and I put a lot of stock into the sort of the commercial spirit and the commercial mindset, right? If we have enough commercial actors that have a vested interest, right, in the hundreds of millions or close to billions of dollars, the hope that I have is they will work together, right? And maybe that's in the form of a registry of some kind where you have notification mechanisms, essentially implementing what some of the things, what some of the principles in the Artemis Accords are, where you have notification, you have registration of your activities, you have consultations, because I truly don't see how without having any of those things in place, how we can avoid conflict on the moon, where there's not going to be any way to, you can go to a court like years later, but if you can't resolve some of those conflicts within, say, hours, I think everybody's going to lose. And with that mindset, I'm actually a little more hopeful rather than pessimistic.
I'm also hopeful, I must say, that you can have two types of evolution. You can have conflicts, and you can say, well, they're likely, or you can have a competitive convergence. So you can have a situation in which the stakeholders will understand that we have to mine the moon and we have to do activities on the moon. ISOM is also another big activity that you can do on the moon. So, for example, refueling and or construction of various types. They will understand that you have to work cooperatively, and I've actually advocated for shared infrastructures. I've written a paper about ISOM advocating for shared infrastructure and mechanism of exclusions of non-cooperative actors in case there are violations. Because environment, it's a big issue, and of course you don't have any terrestrial treaties applicable to the moon, and international instruments like COSPER and sustainability guidelines do not help, because COSPER basically, first of all, they are non-binding, but also they are limited in scope. You have COSPER that focuses primarily on biological contamination, and you have the sustainability guidelines basically work for orbital debris mitigation. And you don't have that for the moon. So it's a big issue, but I'm hopeful. And if I can add a little thing, I believe that prevention may be important. So, for example, another research that I publish is on the legality of defending the national activities on the moon. I think countries will have the right to defend their own activities. So deterrence could become important for defending the national activities that will take place on the moon.
Super. So what do you guys see? What kind of progress might we see over the next 5 or 10 years? Like the most realistic paths forward as we kind of close out these questions.
So I
Any
think
takers?
there will be small shifts in maybe like on the soft law side, right? You're going to have, again, commercial contracts that are maybe going to outpace some of the regulatory frameworks and the international law frameworks, which may then drive soft law frameworks, right? So it may be in the reverse of some of what we see on Earth. But I think that's how it's going to unfold is small steps on the commercial contracting side, on the risk and insurance side, and then have maybe soft law follow some of those things that happen. Because I think Helium-3 is going to be mined in the next 4 or 5 years, correct me if I'm wrong. And I don't know if the international frameworks are going to be able to catch up to that.
Probably not. But as you say, it's not like we are back in the 1960s and 70s where you had a treaty before the state practice. No, it's the reverse. Now we have new commercial actors, public, private, and the states who want to do stuff on the moon. So bit by bit, progressively, all the standard setting function will actually delimit and delineate what are the legal standards and rules which clarify the provisions of the Outer Space Treaty, Moon Agreement if you want, if you have signed and ratified it, and we will move it forward this way. So it will be probably through soft law, but very accepted pieces of soft law. Bear in mind that there is also quite a lot of good faith among actors. So everyone has an interest in doing things that could accommodate the interest and the needs of as many states as possible. So I do believe that probably it's going to be the Artemis program, the implementation of the Artemis program that will do all the legwork in terms of legal standard setting for scientific research first and using resources in support of scientific research first, but then it will be the blueprint for commercial space mining largely.
Yeah, and of course, I mean, commercial space, I mean, they talk with each other and they're for that. So, for example, there are organizations like Cosmic that basically is a consortium for space actors that have in mind projects for ISOM, the in-space assembly and manufacturing. And I believe that you might see in the near future some industry guidelines being promoted by space associations and fora. And maybe there are reasons to be optimistic. Could be in the interest of everybody to work peacefully on the moon.
So, all right, we're wrapping up. We're about to approach questions. So I know you guys are lawyers, but I do have lawyers don't like simple little things. But I'm looking for a yes or no or something very quick on this final question before we go into Q&A. So from a legal perspective, and again, yes or no, counselors, if a company went to the moon, extracted helium-3 from the surface and brought it back to Earth, could they legally sell it as of now?
Yes?
Yes.
From a national perspective, yes.
But not without risk.
I was expecting that. You couldn't just say yes or no. It had to be. That was pretty cool. Coming up pretty soon, there's going to be a pop-up thing. We're just going to ask if the audience would like to see another panel discussion on other related topics that might be legally related. And here's the question popping up on your screen now. So feel free to fill that out. and there'll be a second question that will follow. Let's go into some questions and answers. Let me read through some of these. So here, and we only have like 3 minutes. We should make them fairly quick. So when they invent a private entity, here's the questions from the audience. A private entity was to violate any of the provisions within the 5 treaties that were mentioned. What mechanism would there be for enforcing complacency or compliancy? And who has that responsibility, if anybody?
I can take, okay, Neha.
No,
You can.
no, go ahead.
No, I was saying that, well, we have to distinguish. I mean, here you have from a national perspective, of course, for now in the US, for example, there is not a licensing mechanism for doing lunar activities. And you have this patchwork of like a launch license and spectrum or whatever. But what I'm trying to say is you might have, for example, some repercussions on your license one day. But from the international perspective, you have Article 6. Article 6 that provides that the states are responsible for national activities, even if they are performed by private parties. So internationally, the state of reference, and here we would open up a world discussing which actually would be the application of Article 6, but theoretically, the state of reference would be responsible for the violation.
Another quick question. Here's a fun one. And this might be one of the next month that we're going to be talking about the economics of going to the moon. So if no one can make a claim to ownership, then how can anyone invest capital in a lunar-based enterprise if there's no legal protection?
I think there's a distinction there, right? And we've seen financing, right? We've seen financing for various space resource ventures. It's not that you need to own any part of the moon in order to extract space resources from it. Yes, of course, there are going to be folks, international state actors included, who will not agree with that position. But it's converging on this point where you do not need to own or appropriate that part of the moon in order to own the resource that is extracted from it, in a nutshell.
Another question is a little complicated and probably going to be a topic for one of a future topic. But if there was 2 entities mining the moon, they're close to each other, and one damages the other's equipment, what happens at that point? So the United States and China, they happen to be United States and Chinese companies next to each other, and one of them damages the other equipment. Do they have recourse it presently now? Or is that a topic for the future?
I think that's an entire webinar.
Yes.
But there's the liability convention, whether or not it applies, whether there's any private recourse, are there going to be dispute resolution frameworks that folks agree on, whether it's arbitration or some other mechanism. But I'd say that'd be an entire webinar on its own.
Absolutely, because the company could not go directly to get that kind of damages. It would ask its national state to go and get satisfaction. On the other hand, Article 7 has never been applied in practice, and also Article 6. Not sure if I'm still connected.
Yeah.
You,
Yeah,
Good.
sure. I saw blank for a moment. So, and also Article 6 is very unclear on many, many points. So I would say it would require at least another webinar and perhaps some state practice to find an answer to that.
2 sort of questions sitting out there we probably running out of time to talk about. One is, if a company tries to bring back one and there's a lot of zeros next to this person's response, I think it's $10 trillion worth of product from the moon. They're not going to be domiciled in the US, but rather a country with low corporate taxes. So there might be a question about where you bring back these resources to when they land in the ocean. Another one has to do with patent law. That might be a topic for another day. I think that wraps up the key questions. There's a lot of questions in here that I think have already been answered related to Artemis. So I want to thank the panelists and Ken for a phenomenal discussion. up on the screen is our April discussion. So this topic will be about some of the economics. There'll probably be a couple in the series here. Right now, it's a $30,000 gram product to come back to Earth. That price will probably go up for quantum computing and come down so that your electric bill across the globe won't go down. But ultimately, the question is going to the moon, extracting helium-3 going to be a positive return on investment? Will this go from a public to a potentially private-only type of an industry? So please join us on April 15th at 11 o'clock Eastern to find out some answers to these compelling questions. And we will take a look at the poll and see if there's interest from the audience to do another one or two more rounds on the legal aspects of extracting helium-3 and related topics. So thank you, everybody. I appreciate your time.
Thank you, Chris.
Thank you.
Thank you.
Thank you. Great discussion.
Thank you.
Bye.